everybody, welcome to Active Self-Protection Extra. Once again here with defense attorney extraordinaire Tim Forshee of Forshee Law, the guy that certainly you should go to for your NFA trust. Certainly, if I was in a defensive encounter in Arizona and Phoenix, for sure I would call you. You'd be the guy, you will be the guy.
That means a lot, Johnny, thanks.
Rule number one, stay out of gunfights. Rule number two, if you get in a gunfight, I'd call Tim.
Thanks, man.
And I want to talk with Tim today. We're here in the conference room at C2. Thanks to them for letting us use it. I want to talk about a topic that I don't think gets discussed enough, because I really think, the jury is this, one of the four boxes of freedom. Right. But the attorneys, most places and most times, have some input on who gets to sit in that box.
Yes.
So let's talk about the process of choosing a jury. It's what the lawyer nerds call voir dire. To win the fight after the fight, you need help. After a use of force, I trust Firearms Legal Protection to help me win the fight for the rest of my life. From their 24/7 attorney-answered hotline to coverage for the use of all legal tools, Firearms Legal Protection has you covered. Get a discount by signing up at the link below. Although I will say, interestingly, here in Phoenix, we've had this process for a bit here where we didn't have voir dire.
For just a little over a year now, started January 24, the Supreme Court did away with voir dire in Arizona. But by the way, the term voir dire, it's V-O-I-R-D-I-R-E. We always use Latin in the law, and of course, so this is French. So no one knows why, but we use a French term too.
We use Latin because we want to sound important.
Exactly, and we use French because we want to seem arrogant, and jerks, I guess. I don't know.
So we enjoy cheese.
Exactly. Voir dire means to speak the truth, which we certainly don't see enough of these days. So that's kind of a neat term, I guess. But in Arizona, about a little over a year ago, they decided that voir dire was being abused and it was taking too long, and it was driving the length of trials too far. We were taking 2-3 days for jury selection. We didn't need to do that. So we don't have voir dire technically anymore. Now, we still kind of have it, but it depends upon the judge. It depends on the tolerance level of the judge. So some judges will let us submit our voir dire questions, and then they essentially will read all those questions for us, so the jurors don't know which side the questions come from. And in some respects, that might be helpful, because that it might help me mask my agenda, and they might not know if it was me or the prosecutor that asked the question, that sort of thing. So some judges will do that, and that's actually, like I said, that can be tactically helpful. Some judges don't want any input at all, because they're smarter than any lawyer, and they've been doing this plenty long, and they don't need any input, and this is a simple case, and I see what it's about, and blah, blah, blah. I can't remember. I think it's... what was that Al Pacino movie where he said where he lost his temper in front of the jury?
Scent of a Woman.
No. This was where he was an attorney. It was about how corrupt the system was.
Oh gosh, I forget.
Anyway, but he had this great line where he said, "Judge, if you're going to try my case for me," it was The Verdict with Paul Newman. That's what it was. Anyway, so Judge, if you're going to try my case for me, I wish you wouldn't lose it. and there's that mindset. It's like, if the judge is going to intervene and insert themselves into the case, I hope they're at least doing a good job. So, but the jurors, the attorneys usually have some input, and what we're finding now is that the judges will be a lot more flexible with strikes for cause. Used to be you'd have somewhere between 6 and 9 peremptory strikes. Now we don't technically really have peremptory strikes, but you have strikes for cause, and there seems that most judges are being a lot more liberal with that. So in other words, if somebody's like, "Look, Judge, I just don't like this person," a lot of judges will sort of wink at you and say, "Okay, I'm going to strike them for cause." So,
right.
So they're still working with us. I think there's a lot of judges that don't like this new system either, actually. So.
Well, and most places do have the voir dire system where...
In fact, I think we were the first state to do away with it. So, yeah.
And it's still kind of...
I think it's trial. Exactly. I wouldn't be surprised if it comes back. Yeah.
So in that idea, the attorneys for both sides get to submit some questions to the jurors.
Correct.
Like you say, a lot of times it's the attorneys that ask those questions to the jury.
Right.
And at the beginning, those are written questions, right?
Well, you get a juror questionnaire. So when the jurors show up, they have to fill out a questionnaire. Where do you work? Do you know anybody in the prosecutor's office? Do you have any friends who are attorneys? Do you have any friends who are police officers? They ask some general questions in the juror questionnaire.
Boilerplate.
And some of the times, I've said Superior Court cases where the juror questionnaire is like a half sheet, and there's very little information there. I mean, it's their name, their occupation, and their age, and maybe possibly what part of town they're from. There's not a whole lot of info. So, but other times it's more of an in-depth. If it's going to be a lengthy trial, that sort of thing, they'll have more in-depth questions in advance. Yeah.
So then the attorneys can ask questions, because
Correct.
Of course what you're trying to do is figure out, is this juror going to be sympathetic to my case?
Yeah.
Or
what we're supposed to say is
against this?
What we're supposed to say is we're trying to weed out jurors that wouldn't be objective. But that's not what we want. I want jurors that are not subjective. I want jurors that are going to favor my client. right? So it's tactics. And voir dire is important too because it's, in a lot of ways, I mean, some people say the most important part of the case is your opening statement. And other people say, nah, the only part of the case that even really matters is your closing argument. And some people say the case is won or lost during voir dire. I suppose there's a little bit of truth in all those. I mean, you're making an impression on the jury, right? The first chance the jury gets to hear what the case is about, the first chance the jury gets to meet the attorneys is voir dire. And as we all know, first impressions are very important impressions. So,
absolutely.
So you want to get up there and you want to be polite and respectful, maybe use a little humor, but don't go overboard. They don't know you yet, that sort of thing. But you're meeting somebody at a party, and first impressions count a lot. So that's why voir dire can be a very critical part of a case, yes.
So in a self-defense case, Tim, a case, I've got a case coming up right now that's a murder case that I think has a defensive component. And not as the attorney, remember, not attorney here, okay? Just an expert witness.
Just an expert witness. Just the best expert witness in the Western Hemisphere. So
I just get to talk about what I'm good at, which is fun. But what kind of questions do you focus on? I mean, obviously there's going to be other questions because you don't want to just hammer them like, are you willing to allow my client to have shot this guy to death?
Right.
You can't do that.
No.
So what kind of questions would you focus on?
I mean, again, there's a lot of questions you'd love to ask, you'd love to get answers to, but you probably won't be able to. I mean, the old stuff that you learn about in law school, the stuff that I learned when I was fresh out of law school is what magazine subscriptions do you have? What bumper stickers do you have? Are you a member of this organization or that organization? Are you a member of the National Rifle Association? Are you a member of FLP or USCCA or some other pro-gun organization like that? I mean, if you can get answers to those kind of questions, those can be really helpful because some people won't reveal a bias. They won't say, I hate guns, but I mean, I do give money to this anti-gun movement. I mean, if you can find out things like that, that can be really helpful, and people drop their guard a bit because they don't realize that the fact that they subscribe to Time magazine might tell me something versus whether they subscribe to National Review. Just things like that people wouldn't necessarily put together when they're talking out loud. So if I can ask those kinds of questions, I'm going to do that. What kind of magazines do you subscribe to? Do you have bumper stickers on your car? Do your children go to private school, public school? That might not fly. I can't say how much money do you make, but I can kind of get a feel for where they live and what their kids do, that kind of stuff. And that's some of those biases are socioeconomic biases. There's some tags there as well. So I'm just trying to gather information because all we're doing is we're prejudging people. It's all prejudice. I'm trying to get an opinion about somebody that can be completely wrong. And every lawyer will tell you, and I can certainly tell you, that the person that I thought would be the worst juror, that I was so scared of, that I couldn't use my last peremptory strike, but I so much wanted to. I was so worried about her. She ends up being the jury foreman, and she loves my client and loves the case and was the first person to, I mean, you just never know,
So you mentioned here, and I'm sure other people are going to have this question, that, well, there are some questions I can't ask. What questions can't you ask?
I think a lot of jurors will, or a lot of judges will say, no, you're not going to ask them what magazines they subscribe to. It's too intrusive. It's too tangential. I'm not going to allow that. So there's certain things, it's really up to the judge, right? What will and won't be allowed is 100% up to the judge.
100% up to the judge. These are, remember, the judge is the trier of law. Right? The judge is the one who gets to decide whether or not the lawyers are playing by the rules.
Correct, exactly.
And in some sense, it's not like the rule book of, say, we're, when this is being recorded, we're preparing for the Super Bowl, right? You have a rule book, but then there is interpretation of the rules.
Well, just wait. When a judge decides to either overrule or sustain an objection, there's a lot of discretion there. I mean, sometimes I was a judge for 14 years. Sometimes, oh my God, I don't know. I mean, I just have to make a decision. Yeah, I mean,
heads or tails, counselor.
I'm not going to do that. I might be doing that mentally. But the point is, sometimes it's a really close call. And the way I sustain or overrule it, the way I speak, the tone of my voice, all these kinds of things that don't even show up on a trial transcript influence jurors, right? Oh, he's pissing the judge off.
Right.
A judge getting frustrated with him, that kind of stuff. So he must be a jerk. Well, maybe the judge is the jerk.
Yeah.
I mean, and so it really is theater. Then there's just the audience is the jury, and it's theater. And people always ask me, what's the best thing I can do if I want to go to college to be a lawyer? And I always say, take theater classes. Be a theater minor. Learn how to act, learn how to speak, learn how to be an orator.
I'm telling you, being a Toastmaster, if you're going to be a trial attorney, is a big deal.
Amen.
But what are the rules then that the judge has to go by in terms of whether or not they allow a question for voir dire?
There's not a whole lot of well-defined rules. There are rules with regard to, for instance, you can't strike somebody if the defendant is a member of a minority class. You can't do a peremptory strike on a member of the jury pool who's in that same minority class without having to go into chambers with the judge and explain how it has nothing to do with race.
Right. It's going to be a strike for cause.
It's going to be a strike for cause. But if you can't explain a very good rational reason that you want to strike this person, then they're going to err on the side of caution. They're going to deny the strike. So that when you start talking about racial bias kinds of stuff appropriately, that is really, really scrutinized. And there's Supreme Court cases on point. I can't remember the name of the plaintiff, but it was a Kentucky case 20 years ago or so. Maybe it might be 30 now. But that is very closely scrutinized, that sort of thing.
Well, and there's reasons for that.
Yep.
Okay, so I'm listening right now to a series of lectures on Thurgood Marshall and his tenure as a Supreme Court justice, but before that as Solicitor General, and before that his work for the NAACP.
Correct, yeah.
And having cases before the Supreme Court when he was Solicitor General of, we haven't had a black man on a jury for 30 years in this county.
Right.
And so how do I get a jury of his peers if I can't get any of his peers of his same race on the jury?
That's right.
So that's why judges take that super serious.
And I mean, the Supreme Court case doesn't go back that far, right? I mean, this is something we still have to look out for now in certain parts of this country. So, or even not to be naive, maybe every part of this country. Let's be honest, but it's sure as hell a lot better than it was when Thurgood Marshall started out. Oh, boy. So we got to mark that part.
I tell folks, listen, I grew up in the San Francisco Bay Area, and I was born in '76. So I started elementary school in 1980 in kindergarten. And two of my classmates in 1980 were the first black kids to go to school with white kids in their family.
Wow, in 1980.
1980. Yeah, now, again, Brown v. Board of Education was
San Francisco. We're not talking about Tupelo here.
Brown v. Board of Education was 1954. And there we are 26 years later, and these kids whose families had come from other places still hadn't had that. So, those kind of things are big deals. So you can't ask, you can't just strike somebody.
Yeah.
But in terms of the questions, I can't ask a question, are you an NRA member?
Well, I've asked that and got away with it before.
Depends on the judge.
It depends on the judge, yeah. So I've actually had people be able to tell me yes, they were, or no, they weren't. Do you have relatives that are police officers? Are you a shooting enthusiast? Do you have relatives who are shooting enthusiasts? The problem is some of that stuff backfires, right? So yes, I have a relative who's a police officer, and I think he's an arrogant jerk, and I hate all cops. Yes, I'm a shooting enthusiast. John and I are obviously both shooting enthusiasts. You might not want us on a jury in a shooting case because we know enough to know that you screwed up. Most jurors don't know the 4 firearm safety rules. We do. Right. And when I see the video of the shooting and I see you violating all 4 firearm safety rules, I'm not going to be very sympathetic to you. I think you're an idiot that shouldn't have a gun. And I know if you get convicted of a felony, you're going to lose your gun rights. And I'm kind of going to smile about that.
Yeah.
Sometimes what you think is going to be helpful is just exactly the opposite. So you got to be careful about that as well. But as far as what questions you can ask, I have asked, are you a member of the NRA before? I think these days that probably wouldn't be allowed. This was probably 15 years ago, the case I'm thinking of where I asked that. If you ask a definitive question, how do you feel about the cause of self-defense? Do you feel that somebody has a right to defend their life or the life of another? The judge might say that calls for some sort of legal conclusion. It's all going to be up to the judge. Sometimes you get away with it. And of course, you don't know if you're going to get away with it until you try it. Is mom going to spank me when I reach into the cookie jar or not? Well, maybe try to find out.
Let me ask and see.
Exactly, I'll see. Maybe I'll try to ask it a little different a second time and make sure I'm getting spanked a second time before I realize, okay, I better move on. So.
Well, and things like, okay, so if you have a case where you think the law is on your side, but it may be an unpopular law, maybe you can ask a question, hey, do you feel like you have the ability to judge in line with a law that you disagree with?
Correct. And that's big on death penalty cases. I've never tried a capital case. I hope I never do. But that's big on those, right? If you do find this person guilty and the judge instructs you that there is a death penalty phase, would you be able to honestly and objectively weigh and evaluate that? Or are you so strongly anti-death penalty that you could not do that? And we weed a lot of people out with that. I haven't, but the system does.
And people could very well lie, but that's on them. And of course, we would always say as a juror, answer honestly.
Yeah, please.
Now, I also, listen, it's pretty easy in those. You can, I'm a racist and I hate black people.
Well, you always say you can get out of any jury pool you want to if you're willing to publicly embarrass yourself. But why?
Why?
You're publicly embarrassing yourself. You're basically admitting you're a racist because you don't want to do your civic duty. I mean, I don't understand that. Typically, the 2 ways that we define American citizenship are voting and jury duty, and everybody wants to get out of jury duty. If I'm on trial, I don't want people on that jury pool that are trying to get out of jury duty. I want people that are taking it seriously and trying to do a good job. So
I would encourage you to answer honestly, right? To answer legitimately. So if they say, hey, could you enforce this, a law that you disagree with? you might want to think about that.
But there are what we call activist jurors. They have a goal, and I hope I get picked on the jury duty, because I think anybody who's ever worn an orange jumpsuit and has handcuffs on when they drag him into the courthouse that morning is guilty. I don't care. I don't need to hear all this nonsense. He wouldn't have been arrested if he weren't guilty. There are people that are that rubber stamp, right?
Sure.
And there are other people that, I'm going to pretend to be anti-gun so I can get on this jury, and man, I'm going to do everything I can to get this guy, to let this guy go. There's people that will lie under their voir dire. They'll basically give false testimony to get selected on a jury so that they can twist that jury to their agenda. And don't forget, in a criminal case, all it takes, we've all seen 12 Angry Men, it takes one holdout. So if I'm going to decide, there's no way on God's earth I'm going to find this guy guilty, or there's no way on God's earth I'm going to acquit this guy, best case scenario, that's a hung jury.
Yeah.
So one person can really be a cog in the wheel and mess it up. So, or be a piece of sand in the cogs of the wheels, rather.
But also remember, if you do that, you do probably leave the door open for the prosecutor to try again. Because again, a mistrial, a hung jury is a mistrial. A mistrial never happened. Mm-hmm. And so it is back to square one. And if the prosecutor decides, we're going to take another bite at that apple.
I will tell you that as a defense attorney, I love mistrials. I love it, because it's a small victory, but now if they do try the case again, I've got the entire map of the case.
Yeah, what their argument is.
And I've had cases where I can get the trial transcript from the first trial and then impeach the hell out of the witness on the testimony from the first trial. Well, sir, I can't say there was another trial. I can't tell the jury there's another trial, but I can say you gave a sworn statement back on June 18th where you said this gun was the gun that you saw. Now you're saying this gun is the gun that you saw. So which gun is it, sir? And so it just gives me a roadmap. It gives me more ability than I would have had just from victim interviews and that sort of thing. So it's I don't mind them. Plus, you get paid twice. So
so voir dire.
Let's never forget, folks, that I'm a whore. All lawyers are whores. Some of us are polite.
They got to pay their bills. Be nice. So this is an interesting part of the trial system, is that it is a wide latitude portion of the trial system. The judge gets a lot of discretion here.
Big time.
That can be an issue for appeal. If something goes wrong here, hey, the judge didn't allow this line of question or did allow this line of question, so we didn't get an unbiased jury pool. And that can be a line, but it's a difficult line. And so it's an important part of any criminal trial.
And we can roadmap a lot of that out too, because everybody always forgets to talk about this, but we can file what are called motions in limine before the trial starts. And we can ask the judge, Judge, I think it's incredibly important, and here's case law to support my position. It's incredibly important that I be allowed to ask this line of questions during voir dire. Or it's incredibly important that the prosecution not be allowed to go through this line of questioning during voir dire, and here's the case law to support that. So we try to argue some of that stuff before the trial ever starts. We might go in 2 days before the trial starts to get rulings on those motions in limine, and that way we know what voir dire we can ask, what voir dire we can't ask, and that speeds things up and it avoids unnecessary work, and et cetera. And also, you don't look like an inept idiot in front of the jury. I mean, remember, the jury's in the room when you're asking these questions. So if I keep asking questions and the judge keeps interrupting me and telling me I can't go there, I'm losing my case already. I look like an idiot. So it eliminates that stuff.
And this is a reason that if, God forbid, you're ever charged with a self-defense incident that you get in, I'm assuming, of course, that you're a good, sane, sober, moral, prudent person.
Or you wouldn't be watching this.
That you're not a moron who's out committing aggravated assault. But you want an experienced attorney. And at some point, everybody has to do their first case, right? Every attorney has to do their first case. And that doesn't make them bad either, Doesn't make them bad. But hopefully by the time they're lead on the first case, they have sat in trial and been second chair a bunch and seen it done successfully and well. You don't want somebody with no experience going in on your attempted murder charge.
Right.
That's a bad day. Because of how you ask those questions, how you file the motions ahead of time, how you frame that problem, and how you present yourself to the jury matters entirely. And maybe on another one, we're going to talk about what it means about you as the defendant in front of the jury, but that'll be for another day. Tim, this education, I think, is one that I've never seen anybody else talk about, so thank you.
Well, great. We spoke the truth.
We did. We did. We voir dired today.
We voir dired the hell out of this thing today. So.
Have a great day, everybody.
Take care.